Want to start?
Yeah, I'm good.
Sure. All right, good morning. It is 8:57 a.m. on August 21st, 2025. This is the second regularly conducted docket of the Oil Conservation Division's status conferences, although we do have a hearing by affidavit to start us off. So I'm going to call case number 24849 of on operating. Good morning.
Good morning, Mr. Examiner, Mr. Technical Examiner. This is Dina Bennett on behalf of Coterra, who succeeded to Avant's interests in this acreage.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of Matador Production Company. And we've just entered an appearance. We objected, we withdrew the objection.
And Ms. Vance, did you see the latest filing from Ms. Bennett?
I did, and we have no issue with it.
Okay, very good. So Ms. Bennett, the technical examiner and I reviewed your submission showing that you did provide notice to that one operator. What does MVDR stand for?
I don't know.
Oh, okay. All right. Anyway, you provided it more than 20 days ago for today's hearing. So do you know if they're represented by anyone?
They have not entered an appearance, and they've never indicated to me that they were represented by anyone.
Okay.
Or to Coterra, as far as I know.
All right. Well, you've satisfied the legal notice requirements, so this case will be taken under advisement at this point. Thank you.
Thank you very much.
Moving on to case number 2. This is Pride Energy 25312. Looks like it is merged with 25455 for the purposes of a hearing. Entrance, please.
Sharon Shaheen on behalf of Pride Energy.
Morning.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of EOG.
Good morning. And what is this? What is the status of your, could it be one of the microphones that's on in the room on a computer? Thank you. I think it's better. Well, whatever happened, it worked. So what's the status of your objection at this point?
So right now, and Ms. Shaheen and I have conferred throughout the week, but basically there is a agreement in place, but it's not finalized. So we would like to ask for another status conference. I understand that the division may not want that. And if that were the case, then we would ask for a contested hearing date as far out as possible, because I believe we'll be able to get this done within the next week or so.
Ms. Shaheen?
I agree with Ms. Vance. I spoke with my client and he believes that it will be finally papered up within a week. They're simply waiting on exhibits, and I understand from Ms. Vance that the person in charge of the exhibits was out yesterday, today, and tomorrow. So we think it will be papered up and signed within the next week. We would ask that it be continued, but obviously if we need to set it for a contested hearing, we can do that. And at that point, Pride will dismiss its application.
Even though your case was filed first?
Yes, EOG will be drilling the acreage that Pride intended to drill.
I see.
Mr. Examiner, this is Jim Bruce representing Kaiser Francis Oil Company. I just want to get my appearance of record.
And what's the status of your entry? Is there an objection?
No.
Are there any other parties?
Yes, Jackie McLean on behalf of Red River Energy Partners, and we've just entered and are not objecting.
Thank you.
And Mr. Examiner, Carrie Hatley entering an appearance on behalf of COG Operating. We are just monitoring.
Perfect. Let me look at the history 25312. 25312. Ms. Shaheen, did we issue a pre-hearing order in this case?
Yes,
Thought so.
it was set for a contested hearing on, I think, the 16th. It might have been the 11th. And that was vacated because we had reached an agreement in principle and needed to paper up the agreement. And I'll just note that these applications were filed for the May docket, so they haven't been sitting there for that long. We moved fairly quickly to get to a resolution, and I think, again, it'll happen within the next week or so.
Mhm. Well, I don't have a connection to the internet for some reason, so I just have to rely on the parties at this point. Machine, when did you file your application?
I believe they were filed the end of March for the May docket.
Okay. When you say they, why do you say they?
Oh, sorry, it's just one application.
Right. Okay. So March, and the pre-hearing order set the hearing for, was it July or August?
August.
August. But we received a motion to vacate that based on what you said about the settlement negotiations going on. But did we not come to a status conference before this when was the last time we heard your case?
I believe it was on the 2nd July
I
docket.
thought so. And at that time you said, let's have another status conference because we're close.
I believe so. That's correct. Mr. Felderwert was here.
Okay.
That's all correct. And also just as
Yeah.
far as filing goes, we filed our application at the beginning of June. So just to give a little bit more history
Yeah.
there. So
Perfect. Well, I anticipated that this would be the last status conference we'd have in these cases. So what I'll do is we'll issue another pre-hearing order for another status conference. You say it'll be another week or two before this should be concluded. Okay. Why don't we see what dates are available in late September, over a month away? Freya?
The late September date is September 30th. We also have September 16th.
Let's go with the 30th. So Freya, will you issue a pre-hearing order? I guess, would that be an amended pre-hearing order since we've already issued one, but then we vacated it? What's the effect of vacating it, Ms. Sheen?
I think it no longer has any effect.
I agree. Okay. Okay, so we'll have to issue the second pre-hearing order. Okay, Freya?
Okay.
All right. September 30th. Is that a trailing docket or is that the only one on the docket?
It's the only one so
All
far.
right, perfect. So it'll be the first one. We won't come back for another status conference. When the parties resolve this, just file a motion to vacate and I guess dismiss your case, Ms. Sheen.
Yes.
So why don't you file the motion to dismiss and vacate the hearing order in your case? We'll do that. And then we'll come on the record. We'll move your case. It depends on when you resolve this. Maybe we can move it to the earlier September case for a hearing by affidavit. But if not, then the first one in October, depending.
understood.
All
That
right.
works.
Sounds good. Anything further, Machine?
Not from Pride. Thank you.
Good.
Nothing.
All right, thank you. All right, well, good luck to the parties. Now, do I even have the docket anymore in front of me? Yes, okay. Moving on to number 4 on the docket, this is Paloma Permian 25470. Entries, please.
Good morning, Mr. Examiner. Dina Bennett from Model Sperling on behalf of Paloma Permian.
Thank you.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of COG.
And did you object?
Yes, we have filed a entry of appearance and objection to these cases,
When did you do that?
or this case.
Yeah.
We did that. I can, if you give me a second.
And if Ms. Bennett knows, Ms. Bennett, do you know when they objected?
I don't know when they
Okay.
objected, but it was about a week ago, probably.
All right.
It was sometime
Maybe.
last month, I
Okay,
think.
so in July. Okay, what's your plans, Miss Vance?
Well, Ms. Bennett and I, we spoke yesterday, and it's my understanding this morning that Paloma would like to move forward with a contested hearing regarding the application that they have filed. That being said, I think at this point we will plan on filing our own competing cases. And we would request a hearing date sometime, a contested hearing date sometime in November, primarily because of witness availability.
Miss Bennett?
Thank you. Paloma would like to have a contested hearing set as quickly as possible. They would like to go to hearing in October, and I've already had some initial conversations with Paloma about their availability, and they noted that I was looking at Tuesdays in October, and they said October 14th would work for them if that's possible. They have APDs in hand, they have a rig, they're ready to move on this, and they don't want to have any further delay.
Okay, I understand. So first, let's go to Freya. Freya, what dates do we have available in October for a hearing?
For October, we have October 28th, and that's it because of the OCC rulemaking that's expected to be about 3 weeks.
Now, of course, we could hold the hearing virtually, right?
Yes.
All right, so is October 14th available if we did it virtually?
Yes, that would work.
All right, Ms. Vance, let's talk about your competing is it applications you said, multiple?
Yes, there will
Yes.
be 2 cases that we file
2 cases.
Mhm.
Okay, 2 cases to compete with 1.
to compete with one. That's
Okay,
correct.
All right. When,
And may I just, can I give a little color?
Yeah, sure.
COG is the operator in this area, already has existing wells.
Okay.
And also we have filed a bone spring application to go along with these cases. And so, again, it would be our preference to push this out, to have some time on this, have all of the cases heard together. But again, I understand what Ms. Bennett is saying, but COG already has existing development here, has a significant interest, and the parties I do know are having some negotiations, but I think it would be more fruitful, at least from our perspective, to push this out some more. And hopefully the parties could resolve their issues. But either way, even if it goes to a contested hearing, our strong preference would be sometime in November, to go along with also our witness availability.
well, seeing as we're doing this virtually, and Ms. Vance, that I give preference to the operator, the applicant, who has a case here in front of us. I prefer to do it in October. It's 2 months from now. I mean, it's only the 20th of August today, or 21st. So we're talking about almost 2 months from now to have your witnesses available and get your cases filed properly. Have you sent out proposals?
We have, and again, there were some revised proposals that went out, and from what I understand, the parties are discussing those. But COG, our preference, strong preference would be to push this out to November regardless. And I understand you're saying that we could be hybrid, but that doesn't mean my witnesses will be available, because they would be, most likely they would be appearing virtually anyway for a contested hearing. So it's strictly availability itself.
Okay. Well, if what we'll do is we'll issue a pre-hearing order for October 14. And Ms. Vance, if your witnesses file affidavits saying that they just cannot appear virtually and they cannot have another expert testify in their place, then we'll adjust it. But I'm certainly not going to adjust it into November. That's too far away for me.
May I ask one thing? Freya said that there is a available date at the end of October. If there was to be a split of the differences here between the parties, could we at least push it to the end of October?
Miss Bennett?
Thank you. Paloma would still want to go on the 14th, but because the 28th, although it's still in October, it does seem a ways away. And I think what Paloma's preference would be is if Ms. Vance, if COG's witnesses aren't available on the 14th, then we could go on the 28th as a fallback position. Okay. As I mentioned, I did already clear the 14th with Paloma and they're available. Okay. So that's their preference. But if we have to go to the 28th due to witness availability, then Paloma would be ready to go on the 28th as well.
Okay. All right. So Ms. Vance, it's up to you to check with your witnesses and let us know if they're available on the 14th. That's our preference. If they're not, then we'll do the 28th. The problem with the 28th is that I'm not available on the 29th through the 4th of November. So if we don't conclude in one day, the case would have to be continued for a week or so until after the 4th of November.
Two questions. One, in that case, would that particular docket, does it start at 9 o'clock or is it one of the ones that starts in the afternoon?
Which docket?
The 28th.
Freya? I think it'd be more.
It would be 9 o'clock.
9 o'clock. And we can even start at 8 o'clock if we need to.
Okay. And then as far as an affidavit, what is the threshold you would like to see?
Well, why are they not available?
Okay.
Something sworn under penalty of perjury that, I am not available. Here's why. And there's no one else who can testify in my place. That's what I'd want.
Okay.
So Freya, we're going to hold off on issuing the pre-hearing order in this case. Let's wait until when would you be able to either agree to the 14th or file what you need to?
I have until next week, maybe sure. Wednesday, Wednesday-ish, I think. Perfect. Would be okay.
Sure. So let's see what date that is. Hold on. I show the 27th.
I think that should work. Yeah.
Okay. So then we won't issue the pre-hearing order until the 28th of August, waiting to hear from Ms. Vance and COG on their witness availability. So Ms. Bennett, I know it's your preference to be the 14th. It's my preference too. We'll see what Ms. Vance's client can do. And then once you file your applications, Ms. Vance, would you also file a motion to consolidate?
Yes.
All right, sounds good. When do you anticipate that, by the way?
I think maybe sometime next week. I think I just need to touch base with COG and see where we are with things. But I anticipate sometime in the next week or two, which should be plenty of time for notice and all of that.
Right. So. Ms. Bennett, have you seen these proposals?
I have not, but I do know that Paloma has seen at least the original proposals. I'm not aware of new proposals. That doesn't mean that there shouldn't be anything read into that. I just
Okay.
don't know if there were new proposals, but I do know that Paloma has seen at least one set of proposals. I can't say whether it's the new ones or the original ones. So they have seen the proposal letters.
Okay, perfect. Anything further, Ms. Vance?
No, that's it.
Ms. Bennett?
Nothing further. Thank you very much.
All right, we're off the record in this case. Let's move on to AEP 2 operating. This is number 5 on our docket, 25496. Entries, please.
Good morning, Mr. Hearing Examiner. Good morning, Technical Examiner. Darren Savage appearing on behalf of Alpha Energy Partners 2 LLC.
Good morning, Mr. Examiner. Carrie Hatley entering her appearance on behalf of ConocoPhillips Company.
Good morning, Dina Bennett on behalf of the City of Carlsbad.
I am waiting for Mr. Samanyengo, and I'm waiting for, is it Mr. Anderson? Are either of those parties on with us?
Mr. Hearing Examiner, in the last hearing we had with,
Hold on, I heard something. Hold on one second. Go ahead.
Yes, Mr. Anderson is here, Mr. Examiner.
Okay, so you're entering an appearance for who?
I'm the landowner for the property in Eddy County, New Mexico.
Yes, sir. My question is, you're entering an appearance for, is it just you, or is it you and your wife, or is there anyone else?
I'm entering an appearance for Warren Anderson and Lily Anderson, sir.
Okay, perfect. Thank you. And I did get that document that you emailed today. It would be helpful if you would put a case number on your filing so we know where to put them, since you're not able to file them directly into the case yourself, okay?
Yes, sir.
All right, so you'll have a chance to speak. I just want to get all the entries of appearance first. Do we not have Coterra Energy, Beatty and Wozniak with us? Okay.
Mr. Hearing Examiner, this is Dina Bennett from Module. I'm also appearing on behalf of Coterra Energy, Magnum Hunter.
Okay. Okay. Mr. Samanyengo, are you with us? Okay, Mr. Savage, what were you saying?
I was saying that the last meeting we had on this, that it was ruled that Mr. Samaniego did not have standing because he had no ownership. Thank you.
I wonder, Freya, if you could remove that entry of appearance?
Yes.
Okay, great. Okay, so Mr. Savage, this is your case. I know it's been objected. How many, Mr. Savage, how many parties have objected to this case?
As my understanding, it's just Mr. Anderson,
Oh.
and that was based on the offer.
Yes.
So as I understand, the current status of this case is that Mr. Anderson has objected to it, and that's the only party that has objected to it. This was one case of 4. The other ones have been heard by affidavit, and this is the remaining case.
Mm-hmm.
So the only thing at issue in this case is that Mr. Anderson has a right to have a full hearing with witnesses because he has standing in his ownership. And I confirmed that in the rules, and I sent Ms. Chance the confirmation on that. So that's not an issue. The only thing there's no competing applications. If I could elaborate a little bit or clarify the minimum standard with the OCD and OCC for good faith effort to reach a voluntary agreement, and that's what is required the effort required to be made before you can proceed with a forced pooling. And I can show you the cases on this, but the minimum requirement is basically sending out the well proposal and perhaps one email or one form of correspondence. But the well proposal basically satisfies the good faith effort.
So let me interrupt you. I get where you're going with this. So what I think you're saying is, why don't we have a hearing as soon as possible just on the issue of good faith? Of course, you'll present the case by affidavit. Mr. Anderson will be there to testify under oath. as to his dealings with your client. And then we will take the case under advisement at that point and make a decision.
Yes, and Mr. Anderson does have a right to a full hearing. So our witnesses would be available and would provide any testimony. So yes, that would be basically the.
Right. Okay. When do you want to have it heard?
As soon as what's available.
Freya?
I don't know if next week, Tuesday is too soon.
It's not too soon for me. If it's not.
That's too soon for me, because, hello?
Yeah, Mr. Anderson, we haven't, Mr. Anderson, we haven't called on you yet. So hold on one
Oh,
second.
I'm sorry. Okay.
That's
sorry.
okay. What's the date, Freya?
The 26th.
The 26th. So first of all, let me go to the applicant. Mr. Savage, would your witnesses be available on the 26th?
Yes.
Okay. Mr. Anderson, what's the problem with the 26th?
The problem with the 26th is, I have to be in the dentist and I have a like surgery going on. I broke my tooth, and on that I need at least 2 weeks to get my attorney.
Okay. Mr. Savage, when was this case filed?
So it was filed. So we had the hearing by affidavit on the other cases last month, and that was at the regular docket for hearings by affidavit. So that was this case was grouped with that. So it was filed at least 30 days before that. So
Okay.
at least 2 months ago, if not more.
Mr. Anderson, when did you enter an appearance on this case?
I entered an appearance on this case on the 7th of this month.
Of this month. And how long have you been negotiating with Alpha Energy Partners?
Oh, I've been trying to negotiate with Alpha since I believe the latter part of 23, 24.
So it's that long. Did you receive the well proposal, the well proposals in this case?
I believe I received the when you say the well proposals, would that be the pulling application?
Mr. Savage?
He would have received a copy of the pooling application, but he also before that would have received the pooling, the well proposal, and my witness is online to confirm that was sent.
Okay. Do you know when?
He would know that usually well proposals are sent quite a bit prior to the application. So can we have John Kaufman
Sure.
provide a?
Sure.
Mr. Kaufman, are you online?
Yes, I'm here.
Mr. Kaufman, when did, I'm not going to put you under oath because this is not evidence right now. I'm just asking, when did you send the will proposal for this case to Mr. Warren Anderson?
It looks like it was sent on 6/23.
Okay, May 23rd. Mr. Anderson, do you acknowledge getting something in late June?
Yes, sir, I do.
Okay, all right, sounds good. And so, Mr. Anderson, this is one of 4 cases that's being held up because of your objection. You have a right to object. You have a right to take Alpha Energy Partners to a hearing. But you do not have a right to delay that hearing. So the fact that you have not gotten a attorney to represent you at this point, I would suggest you get one right away.
No problem, sir.
All right. And when it comes to the hearing, we're going to have a hearing on one issue only. We're going to have a hearing on your accusation that Alpha Energy Partners has not been dealing with you in good faith.
Okay. When you how do you come to that conclusion, sir?
Because I read the document you filed with me.
Okay.
Are you alleging that there's some other problem with this application?
I'm just what I'm saying is what's wrong with this application is that I don't think that I think the criteria is off because they're offering what they say they're offering as a standard, but that would be fine for a person who had 1,000 acres or so many acres, but I don't have 1,000 or so many acres. So I'm just seeing how could they offer me the same offer as that when I don't have that many acreage? How could
Okay.
that standard be fair?
Okay, well, the witnesses will be here for you to cross-examine, so you can cross-examine, especially Mr. Kaufman, who is the landman, who I think would be the most appropriate witness for you to ask questions to. But I'm trying to set a date for a hearing, and you said that next Tuesday you have a dentist appointment, is that right?
I have to get surgery on my tooth, yes.
Okay, all right, sounds good. So you'll be available the next day?
Could you get, I couldn't get 2 weeks, sir?
No,
I'm
that's
just
too long.
asking for 2 weeks.
No, that's too long. I'm not going to delay this case based on tooth surgery. I will delay it, but not that long. So so are you available on Wednesday, the 27th?
If I have to be, I just have to be. I don't know how, I don't know if you ever had root canal and surgery or what have you, but
Okay. All right. So Mr. Anderson, I'm going to set this case for 9 a.m. Mountain Standard Time on the 27th, which is Wednesday of next week. And you will have the witnesses available to cross-examine. I would suggest preparing a list of questions for the witnesses in advance so that it goes smoothly for you.
I do. Okay. I do have a list of questions, sir.
Well, that's great. And also, I would highly recommend that you review the exhibits. Do we have any exhibits for him to? We do have. Have you filed them already in this case?
Yes,
What's the, Mr. Anderson, do you know how, can you just email Mr. Anderson the
we'll do that.
exhibits?
Yes.
Okay, so Mr. Anderson, Mr. Savage, the attorney for AEP Operating, is going to email you a copy of the exhibits filed in this case. The exhibits will become evidence once they are accepted by myself on Wednesday. Unless you object to something, you'd have to make a legal argument about why they could not be received into evidence. But I would review those exhibits. If you get an attorney, give the exhibits to the attorney so that they can review them in advance.
Yes, I'll do that.
All right. Now, you know that we're an hour ahead of you.
Yes.
Okay. All right. And we're going to start promptly at 9 a.m.
Yes, sir. Okay.
Now, Mr. Savage, your witnesses are not going to be here, right?
We'd prefer to have them online if
Right.
that is an
So
option.
virtual.
Yeah.
I wonder whether, okay, so it'll just be you and me and then Freya and the court reporter and Mr. Anderson will appear virtually. Is there anything else, Mr. Anderson?
At this time, no, I just have to come ready and I'll be ready.
Okay, very good. Mr. Savage, anything further on this case?
No, thank you.
All right. Well, Mr. Anderson, good luck with your root canal next Tuesday, and we'll see you next Wednesday morning.
Okay, thank you, sir.
Thank
No
you.
problem.
We're off the record in this case. Let's go to Coterra Energy 25508.
Good morning, Mr. Examiner, Adina Bennett on behalf of Coterra Energy Operating.
Thank you.
And Jackie McLean on behalf of Permian Resources Operating.
Good morning. Okay, and Ms. McLean, do you want to tell us what's going on with your position?
Sure, certainly. So Permian Resources filed an objection initially to Coterra's request for an extension of their pooling order. And then subsequently, we filed a pooling application for acreage that overlaps with Coterra's Ruby wells, which are the subject of the extension request. And we've done this because, one, we're ready to, battle the request for extension and go to a contested hearing on that. We'll present witnesses and testimony. And then in the hopes of, prevailing, Permian Resources has a lease obligation that they have to meet for this acreage in the east half of section 22. And so they want to tee up this application and, any contested hearing that may come of that so that they can move forward as quickly as possible.
So, Ms. Bennett, before I come to you, I want to explore this concept a little further, because it was my understanding that when it comes to an extension, the sole grounds of contention would be good cause.
Yes.
Okay. So let me refine my questions a little bit, since we're in agreement of this. So you're saying that we would have a contested hearing on the issue of good cause.
Correct.
And if you prevail on that issue, then you're teeing up your case, your competing case. Okay. All right.
Correct.
So you agree with that?
Yes, I agree.
You agree with that?
And would not necessarily be a competing case to Coterra's, current pooling, because at that point their pooling order would be void.
Right.
So we would have the only application for that acreage. Coterra could then, choose to file their competing application for that same acreage. But that's why we've done it this way, because we do understand, we've been through this before. We've listened to one of Ms. Bennett's cases where they did this, but we are here today to say we will fight the good cause request for the extension, and then we'll be ready to proceed forward with our application.
Okay. And Ms. Bennett, I saw you shaking your head. What don't you agree with?
Well, as Ms. McLean pointed out, I have had experience with this very issue, and with a situation where I was in Ms. McLean's position for a client. And so I'm glad to hear that we're all in agreement that the contested hearing would only be on good cause. And I was shaking my head primarily because, Permian's position here is that they have a lease expiration issue. And so what they want to do is fight Coterra's extension request, and then have Coterra submit competing applications and go to a contested hearing on those competing applications. That seems very inconsistent with the idea of getting this acreage developed quickly. That could take months, if not longer. And so I'm mostly just surprised to hear that that's the path forward, because it does seem inconsistent with the idea of getting this acreage developed. That being said, Coterra is really desirous of having further communications with Permian and wants to work this out. I had a call with Permian's counsel yesterday where I expressed that, and I'm hopeful that Permian and Coterra will be able to figure out an amicable resolution to this so that we don't find ourselves in that spot of just delay. And so as the initial applicant here, I would request that we have a status conference on September 25th to allow time for the parties to actually have more time to discuss, and hopefully by then we'll be able to, they'll have reached an agreement and we can actually move forward to get this acreage developed timely.
Okay, thank you, Ms. Bennett. I'm thinking about the request for another status conference. When was your application for an extension filed?
I filed it on July 8th.
Okay, you filed it July.
August 7th was would have
Right.
been the first date for a hearing. So this is the first time we've been before the division.
Okay. When does the order expire?
The order expires, I believe, at the end of August. I don't have that right in front of me, but the division's precedent has been that as long as we submit an application prior to the expiration of the order, that we have sort of told the expiration of the order.
And what what is the grounds for good cause in this case? Just without going into great detail, what's going on?
One issue is that Coterra only recently acquired this acreage in January. And so Coterra has been working through they acquired quite a bit of acreage in January from both Avant and Franklin Mountain Energy. So Coterra has been working through all of its different orders and development plans. And so as things are coming up, they're trying to address them, but they've had their arms full. That's what I know. I haven't had a chance to, talk with Coterra to see if there's more than that. That's what I know is part of the issue here, just in terms of timing, is the amount of acreage that Coterra acquired and the needing time to wrap their arms around it.
Okay, is any of this land BLM land?
I believe, I can't answer that off the top of my head.
It is.
I think it is.
Yes.
And
Okay.
I can check with Coterra to see if they have the APDs for this.
Ms. McLean is nodding her head, so I think she knows that. Now, Ms. McLean, I'm asking about Coterra's land. Is any part of it federal land? And so you know the answer to that, and that's yes.
I'm saying that just by the naming convention of the wells, since it's their FedCom well.
Oh, okay.
So that typically would indicate. That's why I'm just saying yes.
That makes sense. So thank you, Ms. Bennett. So Ms. McLean, why is Permian, you said?
Yes, sir.
Okay. Why is Permian challenging good cause in this case?
Because it's my understanding that they had been talking with Coterra for some time now, and they don't have confidence that they will actually drill these wells by the time they need to meet their lease obligation. And that's why they're moving forward with that. So they don't believe that, they've moved expeditiously enough or that there's good cause.
And you're saying when you were talking about their obligations to drill, you were talking about Coterra's obligations.
No, Permian Resources obligations.
How does Permian Resources obligations to drill affect Coterra's extension, though? I don't understand that.
So in section 22,
Okay.
Permian and Coterra have overlapping,
Okay.
Leases on acreage, right? And Permian and Permian had signed on to Coterra's initial plans.
Mhm.
However, it was subject to this farm-in agreement that Permian Resources has that expires next year. And so Permian has to have drilling commence by either Permian or Coterra by that deadline for them to have that lease stay in place. Coterra is very well aware of this, and they haven't done anything to indicate that they're moving forward with this acreage. And that's why Permian is, objecting to the good cause here. They don't think there's good cause, and they don't think that they will actually drill this acreage. So we're going to, we would present evidence on all of that at the hearing.
So I don't understand enough about a farm-in agreement to understand. So you're saying that Permian and Coterra both have a lease agreement on the same piece of land?
Well, on the same east half of section 22. I'm not totally sure which part of the east half of section 22.
But some land, so two companies can have a lease agreement on the same piece of land.
Yeah, a lot of times what happens is like someone, let's say Coterra has the lease, right? And then they've assigned out little portions of it, right? Not at the state land office, but like at the county records. And someone they've assigned it out to wants Permian Resources to come in and be the operator of this acreage. Well, then they now have this agreement with that lessee, and they have to meet certain obligations for that, not to expire.
So you're saying that both Permian and Coterra have a right to drill on some part of the shared east half of section 22.
Correct.
Do you agree with that, Miss Bennett?
Well, yesterday, if what she's saying is accurate, then yes, I would agree. But yesterday I did read, or it was either yesterday or the day before yesterday, I reached out to Ms. Hardy and asked what acreage was at issue in terms of the lease expiration, and I haven't heard back.
Well, I'm
from
Miss Hardy here. We've talked to our clients since then.
Well, I understand that, but no one has communicated that to me despite my request for information so that Coterra and Permian could actually have a conversation. At this point, I don't think Coterra, I don't know other than what I've heard today, despite my request for information. So I'm not in a position to agree or not agree.
Okay.
Assuming that she's correct, then yes, they both do have the ability to drill. But like I said, I don't think that the discussions are as far along as we've heard today, just given, for example, the fact that I did not know. I specifically asked and was not told what acreage had the lease or the term assignment on it or the farm out. So I do feel like there's room for further discussions here between Coterra and Permian. I did ask specifically for a name of someone at Permian that Coterra could reach out to. I haven't received that information. I also offered to have Coterra and Permian get together to talk about this. I haven't heard anything back about that offer. So I do think that there's room for discussions, and it just doesn't make sense to me to move forward on a contested hearing, which is going to add delay when we could have a status conference on the 25th, which is just a month from now. And then we could set a contested hearing after that if the parties still haven't had a chance to reach an agreement. But I think it's premature to set a contested hearing at this moment, given the uncertainties.
Ms. McLean?
Yes, thank you. So Permian Resources has been in contact with Scott Richter at Coterra, and they have been emailing back and forth with each other. The ball is in Coterra's court right now. Sean Richter had said that he would be in touch with them, and they have not heard back since then. But they are very well aware of the situation. We were forwarded the email contact in between the two. At this point, Permian Resources is fine with doing a status conference in September. However, we would like to get a contested hearing set for this in the month of October.
Freya, what do we have at the end of September, beginning of October for a contested hearing on the issue of good cause only?
September 30th.
September 30th, that's what I thought. Okay. Ms. Bennett and Ms. McLean, we're going to set a contested hearing for September 30th on the issue of good cause only. I don't think it's going to take that long for that one issue to receive evidence on. The division still has to make a decision on whether good cause exists to extend the underlying order. So that will delay any further hearing on Permian's application. And then I would suspect, Ms. Bennett, you would file also a competing application if for some reason the order went away. Is that right?
Yes, Coterra does intend to drill these wells. And so Coterra would file a competing application. And so we would be having then yet another contested hearing.
Right. Okay, I understand. I think this will help the parties. I always think that having a solid date will help the parties negotiate in good faith. And we don't have a moving target in that respect. So Ms. Bennett and Ms. McLean, would you please notify your parties, your clients of the date, September 30th. Freya, would that be the first case or second case?
It's the first case.
The first case. Okay, very good. Anything further, Ms. Bennett?
Nothing for me, thank you.
Okay, wonderful. Good luck, Ms. Bennett, with your negotiations. And Ms. McLean?
Nothing from us.
All right, we're off the record in this case, and that
Thank
concludes our
you.
business today. Thank you.